honest questions with honest answers. This is Unfiltered, brought to you by the Emergency Medical Minute. Good morning. Welcome back to Unfiltered. We are so fortunate to have Debi Smith here, just a treasure of experience, who's been gracious enough to carve out some time and walk us through kind of the intersection of medicine and law. She does want to give a quick blurb to start with to make sure we understand the purpose of this discussion. So please, Debi, take it away.
I have to meet everybody's expectations, so I'm going to start by saying that nothing of what I say today is intended to be legal advice. Don't rely on it. If you have questions or concerns of a legal nature, please consult your own legal counsel. I'm providing information, but not legal advice during this podcast.
Perfect. I am glad you said that. And it feels appropriate to start the podcast in that way.
I have to.
No, I understand. Well, Debi, thank you again, really, for making the time. We've interacted on a number of different issues, and I'm just thankful that you've been able to come and spend some time with us this morning. Could you walk us through how your career arc, how you got into this, and how your background and your experiences led you to where you are today?
Sure. So I actually started my college experience as a theater major. And I filmed commercials when I was in high school and a little bit in college, and I thought I wanted to be an actress. I went to New York and did some auditions and didn't like the experience at all. So I came back and regrouped and said, okay, what's close to being an actor? A lawyer. And I went to law school thinking I was going to be a litigator, but did not want to do that. Over time, my mother is a nurse. My father is a hospital administrator, and medicine was always a part of my life. So I think it just led me down the path of healthcare law.
That is a fantastic origin story. I have no doubt that you could have been, if you wanted to be, could have been successful in theater and performance. So could you ever have imagined, as you were going through law school or kind of early experiences in law, that you would have wound up spending 30 plus years in healthcare law? Was that ever kind of on your radar?
You know, I never thought about longevity. I'm a very energetic person and love to be challenged. So healthcare law has actually been a very rewarding career for me. Law changes every day. Regulations change on a daily basis almost. So it's really quite rewarding. And at this point in my life, I don't anticipate stopping. So
I hope not. We need your help all the time, more all the time. How have things changed, kind of, as you mentioned, the law changes every day. Over your career, how have you seen healthcare law evolve and progress?
Well, I think healthcare law really touches on every aspect of the law, from criminal law to corporate law to regulatory to litigation. And, the healthcare regulations have changed drastically. We are handcuffed in many, many ways by federal and state regulators. It has a big impact on physicians, on healthcare facilities, how we can operate, what we need to do. Compliance is a huge issue for everybody. So while I haven't really seen it change in terms of it being a regulatory environment, the breadth and the sort of increase in regulations has evolved over time.
Understood. What would you say occupies most of your time in your current position?
Well, that changes on a daily basis.
Podcasting today.
Yeah, podcasting today. I think one day last week I had over 200 emails in a day and spent the whole day responding to emails. I spend a fair bit of time doing contracts. I actually am fortunate enough that I'm working for a company that's very innovative. So I get to spend a lot of time talking with people and planning new ventures, coming up with ideas, thinking about growth opportunities. So, that's very rewarding, and it's a tremendous opportunity.
That's a great point. As you draw up contracts in a new space where either you or the company has not been particularly active before, do you lean on previous experience that you've had? Do you just stick to a set of kind of principles when you're drawing up those contracts, or does it free flow depending on what type of initiative you're trying to get into?
Well, there are certain minimum things that need to be in every contract. You have to deal with HIPAA, and you have to deal with sometimes indemnification, terms of contracts, term and termination clauses, assignment. Those kinds of things are in every contract. But what I try to do is sit down with the folks who are actually going to be impacted by that contract and listen to what it is that they want to accomplish, and then try to draft the contract in that way. Again, I have a tremendous opportunity to be working with people who are very forward thinking, and who also are willing to spend the time with me and sit down and talk about what they would like to do, and then we talk about how we're going to get there.
Yeah.
So,
well, as a person who's been privy to some of those conversations, I can tell you that it is a treasure to have you in that, because your experience in pitfalls of ways folks have pigeonholed themselves because of a contract into something that they don't want to do, or whether it's regulatory things. Your experience in that guides me, it guides all of us when we're trying to get into these new spaces, because I have no doubt that I would get myself into trouble unintentionally. I've gotten myself in enough intentional trouble in my life, but unintentionally I would get myself into trouble without your help. So I certainly appreciate that.
I appreciate that sentiment.
When I'm still relatively early in my career, as you look back and you've dealt with hundreds, thousands of physicians over the course of your career, what would you say, if there are any themes, to a young physician just entering practice? This is an ER kind of focused podcast, but
sure.
What lessons or what advice would you give them to avoid some kind of common pitfalls?
Well, I think one of the biggest challenges for doctors is they have to start out reviewing these contracts and making sure that they're not entering into something that is going to hinder them later. When you're looking at a contract, you've got to pay attention to things like non-compete clauses, and is that going to impact your ability to move later if you choose to do that? What kind of company are you working for? You need to look at that too, and what do they do with their employees, and do they handcuff them from further opportunity, either while they're working for them or in the future? The regulatory environment is also very, very difficult for new docs. ER docs deal with a whole bunch of regulations, EMTALA being one of those, and how EMTALA is interpreted by a healthcare facility and what the physician obligations are changes a little bit from facility to facility, and that's a little bit challenging. I think trying to maintain that ability to exercise independent medical judgment when you're in an employment situation is super important for a doctor. And I think you need to be watching, am I going to work for someone who is going to hinder my ability to practice medicine? You've received the training. The corporation has not, and the corporation should not be interfering with that judgment. I think looking at resources, if you happen to be someone who has a particular interest in an area, are you working for someone, or are you entering into a contract that's going to allow you to seek that growth in your life? And is it going to be yours, or is it going to end up belonging to your company? So things like work product clauses are real important in a contract. There's a lot to think about. It's not just the practice of medicine. It's also about how you see yourself growing and developing, and what kind of relationship are you entering into, and how is that going to impact your plans.
That's great advice. We, as we go through training, become so engrossed in the clinical side of it and the medicine side of it, but I wouldn't say that very many of us feel prepared in that way to engage in the world of contracts, to have the kind of forward thinking, to think of how contracts would impact our practice. Do you have any examples you can think of? It struck me particularly when you mentioned being able to make your independent medical decisions and not to have any sort of corporation or other entity impinge on that. Can you give any examples or any thoughts that you have about how that plays out?
Sure. I think one place that plays out is when you're providing patient care and you're making a decision about, is it appropriate to admit this patient to this facility where I'm sitting in the ED, or does this patient need a higher or a different level of care? And there's that sort of tug of loyalty to the facility you're working at, as well as some administrative pressure probably to keep that patient at the place they came to. Or is it better for that patient to go elsewhere? And you can't let a company impact that decision. That is truly the exercise of medical judgment, and that's your decision with regard to your patient's care.
Thank you. That's a great example. I know we have a large portion of our audience who work in rural settings, and the push-pull of that type of decision is a regular one that they have to work on. We've touched on contracts. We've touched on a little bit of the practice of medicine. Do you have any other kind of interesting legal side or insights or situations that you think are something that docs wind up facing on a regular basis that you'd like to talk about?
Well, one thing that I would recommend is that you protect yourself. If you have a great idea, make sure that idea is protected, possibly through copyright or trademark law if you need to go that route. But also make sure that if you want to share that with your employer or with a facility, that you start with some kind of agreement up front to protect the ownership and the rights to whatever it is you have an idea about. I know over the years I've seen docs come up with sort of automated discharge instructions and patient platforms that we might use to look at reports or to track trends. But the ingenuity that came up with that idea belongs to that physician who came up with it. And be careful about someone taking your ideas. Make sure you're protected.
Got it. I hope to one day have enough valuable ideas I have to worry about protecting them. I don't know.
You work with a number of people who should be inspirational.
That
is
true. That is true. I'm associated with people with excellent, incredible ingenuity and innovation. But one other thing that I think touches on our practice a lot is litigation, and in a number of forms. Certainly the medical malpractice, but also being called to testify as an expert witness. And could you just kind of walk us through, a lot of our docs are young or early in their career and fortunately or unfortunately don't have experience with that system. Could you kind of just walk us through how that would work in terms of, you can pick either one, either the med mal or the expert witness, and just kind of walk folks through what you would expect or how it should go, because as we've talked about, it oftentimes doesn't go as it's supposed to.
Sure. And, I kind of look at this in three different ways, and I have some real frustration with Colorado law in this regard. The first way this comes up is if you've treated a patient and that patient is involved in perhaps a criminal case. Either they're the defendant or they're the alleged victim. And then you are called by a district attorney or a public defender or a private attorney defending the individual who's charged with a crime. Colorado law doesn't protect the time of our healthcare providers. Basically, what can happen is the attorneys can subpoena the physician, not pay them for their time, and use them as a fact witness, because you have personal knowledge about the circumstances that might be relevant in their case. And they call you as a fact witness and then use you as an expert, and they don't pay you. That is very frustrating to me. There are many states who have laws that require there be a minimum dollar amount that be paid to a physician when they're brought into a case. If we had something like that, that would do two things. Number one, it would prevent attorneys from wasting your time if they knew they had to pay you. Mm-hmm. And second, it would compensate you. In many of these cases, what happens, particularly in criminal cases, is the case gets set, then it gets continued, and then it gets continued again and again. And each time they change the date, you're taking time off work, time away from your family, and it ends up being a big use of time. I do appreciate that doctors are very interested in justice and in supporting the system and in supporting their patients, but there needs to be a better balance. And I'm quite frustrated. We get tens of subpoenas every week, and I see the impact that it has on our providers' lives. You know, if you choose to be an expert witness, basically someone who's hired to testify in a case, that can come up in two different ways. Either someone is properly using you as a physician and treating you as an expert witness and paying you for your time, or they're retaining you to be an expert in a case that you were not necessarily involved with to begin with. You have to be a little bit cautious because you don't want to involve yourself in a case that ends up creating law that is adverse to you in the future. So if you're participating in expert witness situations, be cautious with what you're agreeing to do and what kind of cases you're agreeing to be involved in. And then probably the worst way to be involved in a case is to be a defendant yourself. You know, medical malpractice cases are extremely stressful. We happen at our practice to have an insurance company that is a very valuable partner with us and with our providers, and they're very supportive. Hopefully all physicians have that opportunity to have an insurance company that truly acts as their partner. Don't be afraid to report things. If something happens in the care of a patient, they threaten you with a lawsuit, they're particularly uncooperative, something happens and you're concerned, report that to your insurance company. You can report 1,000 claims a week and not have it impact your practice, your insurability, your rates. It protects you. So typically there is a requirement that you report a claim within a certain period of time of when you knew or should have known that the claim could arise. If you fall outside of that reporting window, you could end up not having a defense. So don't be afraid to report. And also, if you work for a company that has general counsel, use your general counsel. Call and ask questions. Ask for help. That's what they're there for.
That's a wonderful overview. Thank you. Thank you. And you have always been approachable in that, in any of those settings. And are there kind of classic mistakes that you see folks, whether they're the young docs who are just inexperienced with how this goes, or is there a blueprint for how folks can get themselves into trouble with these sorts of issues?
Well, I think the biggest mistake someone makes is getting a subpoena and, number one, believing it's valid and that it compels them to provide information. A subpoena compels the attendance at a hearing or a deposition. It does not compel you to provide information. It is not an authorization under HIPAA. You should not be talking to an attorney, to a third party about the care you provided to a patient, and that includes confirming that they were your patient, without having a HIPAA-compliant authorization for use and disclosure of protected health information or a court order. Many physicians will go into court because they have a subpoena and they'll testify thinking that the subpoena authorizes them, and the district attorney or the defense attorney, they want your testimony. So they're not going to protect you. That's not what their job is. Right. You've got to protect yourself. Be very, very cautious about disclosing protected health information without valid authorization to do so.
That's a great piece of advice. Walk hand in hand with your legal counsel because they know the system better than we do. And thank you. That's great. Well, I would ask just kind of as a closing question. Well, twofold. One, what has COVID meant for you in your world? It doesn't feel right to do a podcast and not talk about COVID. Yeah. So that would be one. And then two, if you want to just comment on the future and where you think things are heading, in your field, that's a relatively open-ended question to have you answer.
Sure. COVID's had a big impact. It's impacted patient volumes, which impacts our schedules and keeping people fully employed, which is one stressor. It's impacted our concern for our providers who are on the front lines every single day being exposed to illness. So that's very concerning. It's a big stressor for people for a number of reasons. Not just the part of possibly getting sick, but also the limited resources that were particularly unavailable at the beginning of the pandemic. Mm-hmm. I think we're dealing with more mental health issues now. I think isolation impacts people and fear impacts people. And you guys are all on the front lines having to deal with that. At the beginning of the pandemic, some of the states actually came forward and tried to give some relief to healthcare providers. New York, New Jersey, Michigan, a few other states actually passed executive orders where they were protecting physicians from liability while providing care in the pandemic. And really what they did is they raised the bar. They said, okay, the standard is not negligence, it is gross negligence. Mm-hmm. But then they limited it to a very short period of time, like a month or less. And I think there's still the need for that. So I don't think the stresses on a provider have lessened. I think we're all learning as we go through this. I think employers are understanding a little bit better about what the providers need to navigate these relatively uncharted waters. And, we're going to continue to walk down this path, it seems, and have to figure this out as we go. As far as the legal industry, it really hasn't changed that much over time. Perhaps the breadth of practice increases, but, we still have the same issues that we've always dealt with, risk management, all of those kinds of things I think are particularly important in these times. You have to be flexible and willing to change course as a lawyer. You also have to be sensitive to your clients and provide them the support and the information they need in a way that they can understand and follow. I think the worst mistake lawyers make is getting too legalese, too verbose. As I sit here and talk on this podcast,
no,
never shut up.
You're speaking in plain, perfect English. No issue with that.
But I think lawyers need to be more cognizant of who their client is and need to figure out ways to better meet their needs in a way that is simple to follow and effective.
What advice would you have for anybody who was early on and who wanted to follow in your illustrious career footsteps? Anybody who was looking to get into healthcare law. I mean, any pieces of advice other than what you just said, which I thought was profound.
First of all, say I'm not going anywhere, so I don't need them to follow me. But
damn right, you're damn right. I'm not allowed to go anywhere. Yeah, we need you, Debbie.
I would say healthcare law is just an amazing career, and you actually can subspecialize in healthcare law. You can specialize in the tax issues. You can specialize in risk management. Immigration law even is a huge area in healthcare law. So it presents tremendous opportunity for anybody who wants to be a lawyer in a fast-paced environment that changes all the time, so you will never be bored.
Well, Debbie, your energy is contagious. Your enthusiasm is it's never ending, and we are so thankful to have you and to have your perspective. I know I'm the personal beneficiary of that and on a near daily basis. So thank you, and thank you for the time you've made for us today. I have no doubt that you could have been a star on Broadway, but I think you're a podcasting star.
I can't sing. I'm tone deaf. I never would have made it.
But you're a star for us, and you're a star on this podcasting platform. We would love to have you back anytime because your expertise is one that I think our listeners, whatever environment they're practicing in, they interact with law, with healthcare law, and we are fortunate to have an expert. So thank you.
I appreciate that, and I'm also humbled every day to be working with docs. They are just amazing people, and I appreciate the opportunities that are provided to me.
Well, thank you. We'll continue to partner on things and hopefully move into exciting and new innovative spaces side by side. Thank you very much. Any further things you want to talk about? Anything we didn't cover today on the podcast?
No, I think we went all over the board.
We sure did. We could dive into deep into any of those at another date. But thank you very much, Debbie. We really appreciate it.
I appreciate it.
We are on a quest to provide the world with free medical education. Please help us out by rating us on iTunes, following us on social media, and subscribing to our newsletter at emergencymedicalminute.com.